Discharge. And this is kind of a key thing. When you file bankruptcy, the objective, the goal, what you're after, is you want to get a discharge. And what a discharge really is, it's a legal determination from the court that you have no obligation to pay the debts that arose before you filed. And that's what you want. Everybody wants to get a discharge.
Bill, why would there be somebody that wouldn't go, like in our case, why would somebody not go for the discharge post bankruptcy? I mean, it's a whole, as I learned, it's a whole other process to get the discharge done, but why would you not get the discharge versus getting the discharge?
So why would you file bankruptcy and not get a discharge? Gotcha.
Why start it, not finish it?
Yeah, well, first of all, it happens all the time.
Really?
Why?
Is it due to non-approval?
Well, there's two reasons why you don't get a discharge. Number one, you don't do what you're supposed to do. So anybody can file bankruptcy. I can file something called an emergency petition, which is literally, this is my name, here's my social security number, here are the folks I owe money to, it's just a few pages and you're done. All right? But to get a formal discharge, you have to file all your documents, show up in court about a month later, you have to take certain credit counseling classes, and the trustee has to look at all that stuff and say, you know what, you're okay, I'm gonna let you go. So there's stuff you have to do. Some folks have that home that's being sold on a Monday, and they have no intent to ever really pursue bankruptcy, they just want to stop that sale. So they'll file on that Friday. And what's going to happen is the home's not going to sell. And it's going to be tied up for a month or two because of this bankruptcy. And they're kind of hoping during this month or two they have some leverage to maybe work some type of loan modification or something like that. Happens all the time. Not as much now, but a year or two ago where these things were at issue, happens all the time. The other way you're not going to get discharged is if the bankruptcy court says, you know what, for various reasons, you're not eligible, or we're not going to let you get it because of some bad things you did. It happens sometimes. So, key thing is, yeah.
So when somebody buys a property at a trustee sale, how do you know, and you pay by check for cash, banker's check, how do you know you're getting that property?
Yeah, good question. What a lot of folks do, I would say the folks that do this professionally, is they check, well, there's something called PACER. What's PACER? PACER is basically, it's a very cool system. If you file something in federal court, you can get anything, you have access to anything that's filed. So the folks that do this a lot is they'll monitor PACER to see if the debtor filed bankruptcy. Or in this case, the person who owns the home.
So you have to do that like before 8 o'clock with the trustee?
A lot of folks do. A lot of folks will check, let's say there's a trustee sale on a Monday, they'll check on Friday, and they'll confirm on Saturday, confirm Sunday, and hopefully, and I stress hopefully, they didn't file before you actually bought the home.
And that process is instantaneous, somebody files and it shows up?
It's not instantaneous, but pretty close. Pretty close, yeah. Yeah.
Can you get it online?
Yeah, you have to have a PACER account. Yeah, but anybody can get it. You don't have to be an attorney to have it. So, but yeah. And you literally have access to every federal filing in bankruptcy court. It's
so
wonderful.
You take a chance when you give the check. That's
You do.
why they send you the deed a few weeks later.
Yep, exactly right. Yep. So, and I've had numerous clients where we filed, the foreclosure happened, we had to unwind it. Yeah.
What's the longest period of time you're aware of for it to be unwound? I mean, Monday morning, 9 o'clock, you buy it, you find out at noon that there was a foreclosure filed, a BK filed rather.
Mm-hmm.
What's the longest period of time? I mean, when are you safe? 90? Is it 30 days, 90 days?
Oh, no, that's a good question. Well, if you file ahead of time, yeah, if you're the buyer and you bought a home at a trustee sale, you're probably going to figure out pretty soon, because what you have to figure out ultimately is that you have to figure out that a person who owns the home, who's on title, they filed, right? Not their mom, not their dad, but they actually filed. In my experience, well, eventually they're going to find out how. I don't know. title's going to tell them. What I do typically is I'll just call, or I'll say, hey, listen, our client's filed. I'll let the bank know. The bank in turn tells, essentially what they call the crier, the person who actually sold the property. Eventually they find out. The method or how they find out, I guess it can kind of vary.
What's the safe amount of time? I mean, at what point would, if a BK was filed to stop the foreclosure, how long is like the longest time before?
Well, the reality is,
Days or months?
well, the reality is that if you, there's probably no real right answer, but eventually the buyer is going to find out by some source, through an attorney, through the lender, through the trustee. Someone they're going to find out. Longest period of time, it really doesn't matter in that if you filed BK, then you bought the home at a trustee sale, and eventually that person who filed BK gets a discharge, but you thought you owned the home even a year later, you don't own the home. You can unwind the
Right,
transaction.
well, that's what I'm saying, if you're the buyer, when is it safe to put it in the kitchen?
Good question. Yeah, well, eventually you're going to get the deed. Eventually you get the deed. And I guess there's always a component of risk there, but I haven't been involved in a situation where, someone actually bought the home, put the kitchen in, and 6 months later realized, oh my gosh, John Doe filed bankruptcy. I didn't know that. Probably some due diligence on the buyer's side, but ultimately you're going to get the deed.
Well, you probably shouldn't reconstruct anything until you have a deed in your hand.
Yeah.
Well,
Yeah.
what you're saying is, even if you have the deed in your hand,
Yeah.
it could be unwound later.
Yeah, if they filed beforehand. Exactly.
So I bought my home 17 years ago, I safe, no.
Right?
They have to pay
Good
the
question.
kitchen.
Oh, now there's legal issues, yeah.
Right.
Well, let's just focus on the bankruptcy, but that's a good question, though. Yeah.
Yeah, please bear in mind that the foreclosure, there are still some attached liens against the property. Really? What happens to the other liens? Because foreclosure, the bank is the one, the trustee is the one selling it. What about the other liens?
All right, so,
Because you must have a clean title recorded to the
gotcha.
buyer, right?
All right, so the question is, it's a good question, and it's an interesting issue. So let's just say you have a first, you have a second, and a third, an HOA lien, and, a laundry list of stuff. So you guys know that if the first forecloses, all the other stuff, wiped out.
Yeah.
It's great. It's really, if you're the buyer and the first forecloses, you buy that and trustee sale, it's wonderful. However, if you file bankruptcy, then the foreclosure, and then let's just say you get your deed even, and then I say, listen, you screwed up, we filed ahead of time to unwind everything. Those liens come back to life because you go back to where you kind of started, so they don't go away. Yeah, good question though. Good question. So, all right, discharge. Like I said, unsecured creditors, they're done. They're gone. You have no obligation. And the cool thing about bankruptcy is this: that automatic stay we talked about, it lasts forever. So 2 years later, 3 years later, 10 years later, if a credit card company is going to call you, say, I want to collect the debt that was filed in bankruptcy. So you know what? I have no obligation to pay. If they keep bugging you, and you call guys like me who file motions in court saying this creditor violated the automatic stay, and they have to pay my attorney's fees because I had to show up here in court today. So it's a general rule. If anybody here has filed bankruptcy, they know of somebody, no one's going to bug you because the stick, so to speak, if you do file, is pretty severe. So, unknown creditors. Well, what about if I don't identify somebody on my credit when they file bankruptcy? It's a general rule. If you have something called a no asset case, meaning you don't lose anything, even if you don't identify a creditor, they're still part of the bankruptcy. And the idea is this: you didn't identify one of your Visa cards because you just forgot, and you had a no asset case, meaning that you didn't lose anything. Well, there's, at least where we are in the Ninth Circuit, there's a case that says it doesn't matter. And the idea is this: even if you did identify them and put them on there, it wouldn't have mattered anyways because they wouldn't have gotten a penny. So even if you forget somebody, it's okay. All right. All right, so before I go, secured creditors, and this is an important distinction. If you get a discharge, you have no legal obligation to pay your secured debts unless you want to keep the property. And what I mean by that is this. And this happens. This is probably the most common thing that happens. Someone files bankruptcy, but they have a first and they have a second. But they're still in their home like a year later, and they haven't paid a mortgage, and they want to sell the home. Well, they have to go back and pay the mortgage for that year? No, because that debt arose before the bankruptcy. No obligation to pay the debt. So you can be in your home a year later, 2 years later, 3 years later, without paying mortgages, which happens, and you have no obligation to pay the bank back because that debt arose here before you filed.
What happens post that date? Like if you said they haven't paid in 1 year, 2 years.
Doesn't matter, you have to pay it. You have no legal obligation to pay the mortgage. HOA dues are different.
Right.
We'll talk about that.
They make a payment, does that reinstate the debt?
No. The only way to reinstate the debt is you have to reaffirm the debt. What that means is you actually prepare a document, you file it with the court, and the court says, I'll do it. What happens most of the time is in car situations. If you have a car, you file bankruptcy, you have no legal obligation to pay that car. You don't. You can hand it in, you're fine. You could file bankruptcy, keep it for a year, not make any payments, and let's say it gets repossessed a year later. All right? You have no obligation to pay those car payments for the last 12 months. All right? However, if you want to keep the car, well, most lenders know that. So what the bankruptcy code allows for now is that you have to reaffirm the debt. And you actually, we help clients with this all the time. You prepare a document, you say, you know what, I'm going to reaffirm the debt. You file with the court. What that means is you're agreeing to be liable for that debt even though it was part of your bankruptcy. It's called a reaffirmation agreement. So do they require people to sign reaffirmation agreements for mortgages? Typically, no. Have I received letters from lenders saying, can you please reaffirm the debt? Yes. And our response is, no. I'm not going to reaffirm this debt. Can they make my client reaffirm the debt? No. Do my clients feel obligated to reaffirm it? Some do, some don't. Then I remind them, listen, you may get injured in a year and you can't make your house payments, which would be a bad thing. Do you want to have that personal liability, or do you want to say, I don't want that personal liability, but I can keep my home if I keep making the payments? What do you want? And most of them say, I'm not going to reaffirm the debt. So, but it's a distinction that's really important to understand because, like I said, there's no obligation to pay, but if you want to keep it, you got to pay. Yes?
Well, I had a client, it was a short sale, and we had a buyer and he filed bankruptcy. And so when the bankruptcy was discharged, I wasn't told. And then I found out in time before the trustee sale, and I called the bank. I said, we have a buyer. They said, too late. We're going to go ahead and foreclose. So I'm wondering if a notice of default has been filed on the property, can you still short sale it even though they filed bankruptcy in the middle?
So if a notice of default, make sure I understand this question. Well, first of all, we're going to talk about it in here, but I might as well just bring it. I'll answer it quickly. So if you file bankruptcy and you have a short sale, help me understand the question.
No, the question was, we had a short sale.
Yeah.
And there was a notice of default on the property. And we had a buyer, and in the middle of everything, they filed bankruptcy.
Okay.
And then it got close to the trustee sale, and my client was supposed to tell me when their bankruptcy was discharged, and they didn't. And so then I called the bank. I said, we have a buyer. Can we go ahead with the short sale? And they said, no, it's too late. So my question is, if there's a notice of default filed on the property, and they file a bankruptcy, can you still sell the property as a short sale?
Yeah. So if you file bankruptcy with a pending notice of default, and the seller files bankruptcy or the buyer files bankruptcy?
Seller.
Yeah. So provided you have a bankruptcy in place, meaning it's still an active bankruptcy without a discharge, all right, you cannot sell that home unless you get the blessing from the court. Once the bankruptcy is done with, you get a discharge, or it's closed, and that automatic stay goes away, then you can sell it.
Isn't it up to the lender though, or the servicer, whether they want to allow that to go forward?
Nope.
No.
Nope.
Because the
No, so they
BK
can't short sale.
Cannot. Yeah, and the idea is this, is that when you file bankruptcy, what really technically happens is your stuff, all your assets become the property of the bankruptcy estate. It's under the control, direction, and authority of the court. That's really what happens. And so the court has to say, I'm going to let you sell it. And without that, you can't sell it. So, good question though.
But what if the NOD was filed first, and then after that, they filed bankruptcy?
Well, that's
Yeah,
what I said.
whether it's an NOD or NOS, it doesn't matter.
It doesn't matter.
Doesn't matter.
So it doesn't matter which one came first?
Correct. Yeah.
To follow up on that, you didn't know the discharge date.
Yeah,
Okay,
Right.
let's assume it's not discharged yet, but yet Wells Fargo goes, I'm putting it on the courthouse steps. They're not listening. We've got this bankruptcy sitting here.
Mm-hmm.
Okay, so it comes back to what we were talking about earlier. They can sell it all they want, but it's still sitting in bankruptcy.
Mhm.
It shouldn't have sold.
It's not, yeah, the bottom line is that sale is technically not a legal sale.
Okay.
They don't have what they call standing or the authority to sell the property. They just
Okay.
don't. And so,
They can run their mouths all they want.
Yeah.
Bottom line, bankruptcy's in effect.
exactly. So if you wanted to challenge that sale, you're going to win that fight.
Sure.
You know, granted, they can do whatever they want, I guess, but, you know, most banks are savvy enough to understand bankruptcy rules where
Yeah,
they're
the
not going
customer
to do
service
it.
departments are not.
Yeah, most of the time, those folks are a little bit different.
Okay.
Yeah, in the sense of they don't understand. I meant it that they don't understand a lot of the bankruptcy components. Are they different people? No, I'm sure they're great folks. You know, but you're dealing with some somewhat technical concepts, and a lot of these guys may just not have the understanding of how it works, and they're just saying things. Yeah, so.
On the flip side of that, if you wanted to sell, I've had clients that have specifically excluded from their bankruptcy, taken the home out of the bankruptcy. Is that true? I've seen that happen where they have filed BK, but they've excluded it from the bankruptcy, which allows for the short sale or whatever prior to the foreclosure.
Now, when you file bankruptcy, remember all your assets, your entire estate, becomes the property of the bankruptcy court. You can't exclude stuff. In fact, when I'm telling clients something, I say, you know what? You have to identify all of your assets. Maybe they say, well, I have like $50,000 in my drawer. What should I do?
Shut up.
So what I do as an attorney, I say, you know what? You have to identify your assets. Okay, and you have to identify all your liabilities. And if you want, so if you own a home, if you want to sell it, still within the context of bankruptcy, if you're in that world, and since you filed, you have to get the blessing from the court to say, let's pluck it out of or take it out of the estate, and let's let Jim sell the property. And the reason why typically is you have a good buyer, and you just want to kind of move forward. But for the most part, what happens is that title companies, escrow companies, they don't want to deal with all the filing the motions and taking out of the bankruptcy estate. They just want to make sure that the bankruptcy can be over in a few months. Let's just wait.
So-
That's happened.
So
That's,
it's just a decision. It's either file BK, deal with the house later, or, because BK stops everything.
yeah,
So
Yeah.
it's the client's decision.
yeah.
Or if they're sneaky, like unfortunately, it sounds like they were with her, because her client filed in the midst of her working on the sale,
Yeah,
right?
But
Which
the
is,
bankruptcy was discharged, so that's what makes the difference.
exactly.
Yeah.
You're exactly right.
Yeah.
Exactly right.
So how long does it take, how long does it hold the property up before you can sell it, before it's discharged?
Good question. Okay, so standard bankruptcy, filing date to discharge date, typically about 4 months. Typically. I've had clients that have been in Chapter 7 for a year, but there's issues. There's stuff that happens. Yeah.
Can people hire you the buyers hire you to push the banks faster?
Yeah, in fact, one of my slides will deal with that exact issue, where I had a buyer who had a home worth about $1.4 million, and they were kind of in a really desperate situation to get rid of it. They filed bankruptcy, and they hired us to remove some liens and to get the blessing from the court to sell it. And we'll talk about that. It really is a kind of interesting
Well,
case.
even if the people didn't file for bankruptcy, can you push the, what do you call it, the sale faster?
So if you didn't if you didn't file bankruptcy, can you hire an attorney to push the sale, make it go faster?
Yeah.
Probably kind of a waste of money, to be honest. Yeah, and really, it's an attorney can't necessarily make a transaction go faster. Yeah.
So people would have had to file for bankruptcy, and then you could push the sale faster.
Yeah. What we could do is we could help get that asset, if needed, out of the bankruptcy estate, so it could be sold, even though you're in bankruptcy.
I think that's the problem.
So that's the issue.
So I gotta find
Don't
out.
the funds, if you do that, have to go back into the court to pay the debts? I mean, or you just get to keep the money, or what?
Well, most of the time you're dealing with short sales. You're not dealing with profit.
All right.
Yeah.
All right.
Yeah, but one of my slides, which we will get to soon, it deals with that issue. It's actually it's an interesting issue. Yes.
I just want to make sure I understand. I have a client who's right now in the trustee cell. Period. Filed for bankruptcy. Hasn't paid for 2 years. If the bankruptcy is going to just stop in the trustee cell
Yes.
until the discharge. All the debt all the back payment for the mortgage is going to be wiped. Is that correct? Am I understanding?
Yeah, he has no obligation to pay that debt.
The one prior.
Correct.
How about after the discharge? Now he wants to stay in the property and is still not paying.
Correct. No obligation to pay that mortgage, even
And
after.
if they sell it, it's gone.
It's gone. I have a client now who we filed bankruptcy. She's been in her condo for 3 years, has not made a mortgage payment at all. And she knows eventually they're going to lose it, eventually, but there's no obligation to pay that debt.
Suppose he decides to keep the property and start paying the payments.
Well-
Can he save that property?
No, what you're going to have to do in that situation is because you're technically in default on the loan. And so what you really have to do is you're going to have to negotiate with your lender to get what they call essentially reinstated, or you have to be back in good standing with the loan folk, essentially with the lender. So you have a loan modification, that's what it comes down to.
He has to cure the loan?
Well, well,
No, do a modification.
you need to have a modification where the lender says, we're going to agree to these terms, and if you agree to these terms, we will make sure you're in good standing with the loan. That's what actually has to happen. So.